Okay. Hi, everyone. My name is Lila Silverstein. I'm an appellate public defender from what some of you might call the other Washington. We just call it Washington. Washington is a very liberal state in many respects, but when it comes to fairness in the criminal justice system, we have one of the worst records in the country. And I just wanted to update you all on what's going on up in our neck of the woods. With respect to the death penalty, the problems identified in Furman existed in Washington no less than everywhere else. First of all, the death penalty was imposed randomly on a small subset of the worst offenders. And secondly, to the extent the imposition of the death penalty was not random, it was racially biased. So, how did our state respond? Well, our legislature tried to fix these problems. We actually have some of the strongest statutory safeguards in the country at each of these stages. And in Gregg, the court said that if states truly limited eligibility for the death penalty to the worst of the worst and narrowed discretion at each step, then there wouldn't be room for arbitrary decision-making, and there wouldn't be room for the play of racial prejudices. So that's what we tried to do. In Washington, capital punishment is available only for the crime of aggravated murder. The problem is that the number of aggravating circumstances has increased over the years, and they've been interpreted really broadly. Now, at the selection stage, Washington permits the death penalty only when there are not sufficient mitigating circumstances to merit leniency. And at trial, the jury must find the absence of sufficient mitigating circumstances unanimously and beyond a reasonable doubt. So that sounds pretty protective. But the problem at this stage is that mitigating circumstances can, of course, be just about anything, including this rather vague concept of mercy. So what ends up happening is that mercy is both afforded and withheld in an arbitrary and racially biased manner. But the hope was that this would work. And then, notwithstanding Pulley versus Harris, we do have mandatory proportionality review in Washington, which the court in Gregg seemed to think was important and which you would think would provide an additional layer of protection against arbitrary and racially biased decision-making. But in practice, our Supreme Court has never reversed a death sentence under this provision. So the bottom line is that these post-Furman fixes did not work in Washington. We've had about 300 adults convicted of aggravated murder. Only 5 have been executed. Only 9 are on death row. Those 14 are not the worst of the worst. This is something our governor recognized 2 years ago in imposing a moratorium. That's our governor. And just to explain it a little more, a few of those people on Washington's death row committed aggravated murder against a single victim, but 97 adults committed aggravated murder against multiple victims and are serving life sentences. And it's not as if those murders were quick and painless. Unfortunately, most of them involved extreme cruelty and unspeakable victim suffering, yet those defendants are serving life sentences while a handful of others are on death row. And our governor's not the only one who's recognized that unfairness. 10 years ago, Justice Johnson of our state Supreme Court wrote for 4 dissenters in saying he would have held that Washington's death penalty is unconstitutionally arbitrary. 3.5 years ago, Justice Fairhurst said the same thing in writing for 3 dissenters in a case called State versus Davis. Also in Davis, Justice Wiggins wrote his own dissent. He said he agreed with Justice Fairhurst that the death penalty is imposed randomly and arbitrarily, but he also said it appears that African American defendants are more likely to receive the death penalty than Caucasian defendants, and we should study whether that disparity is statistically significant. Right after that opinion came out, a colleague and I were appointed to represent Alan Gregory on appeal. Mr. Gregory was sentenced to death for the aggravated murder of 1 white woman in Pierce County, Washington. He was only 24 at the time of the crime, and his only prior felony was theft of a skateboard when he was 13 years old. And meanwhile, scores of other defendants with violent felony histories plus an aggravated murder are serving life sentences. So one of the first things we did was to answer Justice Wiggins' call to action and commission a statistical study of Washington's aggravated murder cases. That study was performed by Professor Catherine Beckett and grad student Heather Evans at the University of Washington. The data set they used was the same data set our Supreme Court uses in performing proportionality review. Trial judges, who are presumptively neutral arbiters, fill out reports at the end of each aggravated murder case, and those reports constitute the data set. The regression analysis controlled for case characteristics that are supposed to matter. These case characteristics are reflected in the trial reports. And what the regression analysis showed is that most of the variation in sentencing cannot be explained by relevant case characteristics. And it showed that in Washington, African Americans are 4.5 times more likely to be sentenced to death than other defendants after controlling for those case characteristics that are supposed to matter. And that's obviously untenable. We have had 40 years to fix these problems. We've utterly failed, and it's time to call it. So we have asked our state Supreme Court to strike down Washington's death penalty scheme under the 8th Amendment and under our more protective state constitution. That's a picture of our state constitution over there. So we'll see what they do. And if you want more information, I've provided links to the statistical study and the oral argument in Gregory, which occurred just last month. If these links aren't in your materials, you can always email me if you're interested in them, and you can email me with any questions if you want to know what's going on up in our neck of the woods. Or ask me right now.
Love to be able, but while I'm walking to you, I can also say that we will take pains to put any of the speakers' PowerPoints on the conference website when we're done, so folks can do it.
My only question was the slide of the variables that were controlled for. I wasn't writing quickly enough. So the variables are the number of victims, the number of aggravators, number of mitigators, the criminal history, and what's the last one?
So there's a field in the trial reports, and those weren't the only ones that were
Okay.
controlled for. That's just those are just examples of some of them. But the other thing that was up there was whether the judge indicated there was substantial victim suffering. And that was found to have no effect, presumably because so many of these cases involve substantial victim suffering. Yes? Oh, sorry.
What's the procedural posture of the appeal? Are you already at the state Supreme Court?
Yeah, so we just argued this case on February 25th. And in Washington, the way it works is in capital cases, unlike other cases, arguments are 4 hours. They essentially last all day. It's 2 hours per side as opposed to 20 minutes per side. And our court does take a strong interest in these cases, even though they've never reversed for a disproportionate sentence. What happened is the state at every stage has fought the court on this report. They've moved to strike it. That motion was denied. They said you shouldn't consider it. They didn't come back with their own contrary study or anything like that, even though they had a really long time to do that. We never objected to their motions for extensions of time because we wanted them to have time to challenge this and to consider this important issue, but they didn't come back with anything else. They just told our court, don't look at this. So the court was not happy with that, but they also challenged us a lot about the study because, of course, we commissioned it. And even though we kept saying, you know, the researchers use conventional methodologies, and with every decision that had to be made, they erred on the side of disproving the hypothesis. The court wants to know for sure that they're going to be able to rely on a reliable study. So they actually issued this order. Can you hand this to me? Thank you. So just a couple weeks ago, we got an order saying, before oral argument, the state moved to strike the report, and this court denied the motion. At oral argument, the state requested an opportunity to challenge the report, even though they'd already had 13 months. Sorry, little editorial comment. A majority of the court determined to allow the state the opportunity to challenge the report. Now, therefore, it is ordered a hearing shall be held before Supreme Court Commissioner Pierce on an expedited basis upon the parties' completion of the following. And then what they say is that both parties are supposed to submit proposals for how the Supreme Court commissioner is to conduct a hearing. Is it written interrogatories? Is it a full-blown hearing? Should the court appoint its own independent expert, et cetera? So this is really unusual. Nobody has ever seen an order like this from our Supreme Court, but the proposals are due in a couple of weeks, so that's where it is.
We can do this quick one more, and then.
Thank you, and congratulations on a masterful piece of scholarship and litigation. I have a question about the role of the ACLU. I know early ACLU was involved in trying to get some funding, but I don't know if they ultimately were involved, and if they were involved, whether or not some people then accuse the study of being biased.
So the ACLU did submit an amicus brief, just a standard amicus brief, and it was also signed by 56 retired judges in our state who agree that the death penalty should be struck down. The ACLU did not have anything to do with the study, and also Jeff Robinson spoke for 15 minutes. We gave him 15 minutes of our oral argument time, and he did a wonderful job. So they didn't have anything to do with the study specifically, but they were heavily involved as amici, and you know, sorry, it says stop, and I'm a rule follower because I'm an appellate attorney. But I'd be happy to discuss it more with you. Thank you very much.